Hey guys, it's Scott with you once again on Legal Live. We are without Eddie Farah and Chuck Farah today, but we are blessed with the company of Scott Burleigh and Tom Normandeau coming in from the law firm of Farah and Farah. They're taking over the hosting responsibilities today. Fellas, glad to see you.
Good morning. It's good to be here.
If you guys out there in Radio Land happen to have some legal questions, some calls, give us a call. Reach right out, 855-765-1045. We are standing by to offer you any kind of guidance that we can give you. Joining us also, Shafalika Bachnager. You may recognize her name from doing traffic in the afternoons here on WOKV. She's sitting in with us today as well. Hello, Shafalika. How are you today?
I'm doing very well. Happy to be here.
Once again, guys, 855-765-1045. If you got legal questions, give us a call. Attorneys are standing by. Guys, we were talking right before the show started, and you mentioned wanting to discuss some concerns about PIP and the changes that are going forward with that, or at least that are proposed to go forward with that in some legislation. Clear that up for our listeners. What exactly does PIP represent in your car insurance policy?
That's going to be personal injury protection insurance. It's the no-fault portion of the Florida law. It's been around for about 40 years or so right now, and I think this is about the fifth or sixth time the House is going to try to repeal it and move to mandatory BI.
Now, if the legislation should pass so that PIP is revoked or removed from the policy, how does that impact the consumer? How does that impact drivers? And is it a good thing, a bad thing? Is that a matter of perspective?
It really depends on the perspective that you have. It could be good, it could be bad, simply because right now, whenever somebody's involved in a collision, you automatically have $10,000 of benefits to go to medical providers. If they eliminate the PIP, then you would not have that automatic money, although the person that caused the accident would have a required $25,000 in bodily injury coverage. So the good side would be you know that there's going to be some type of settlement opportunity. However, that means the medical providers would not get paid up front. And so some are concerned that the loss of PIP would mean that there would be the reduction in the treatment available because many medical providers are not going to want to provide treatment when they don't know when they're going to get paid or if they're going to get paid.
Now, in the event of an emergency concern, do they get to make that judgment? Aren't they obligated to respond?
Well, are you talking about as far as like an ambulance or emergency room?
Yeah, exactly. Like, say I'm driving along minding my own business, and somebody else is trucking along, not paying attention. They happen to clobber my car. I happen to need medical assistance as a result. I take a ride in the wambulance, and next thing I know, I'm over there at the emergency room, and they're talking about, oh, wait, you don't have PIP? Sorry, can't help you. Is that an option? Is that how that plays out?
I don't think that'll happen. Hospitals generally will see you. It's just whether or not you're going to get a big fat bill at the end of the day. Right now, they automatically bill your auto insurance, and then a secondary as your health insurance. With no PIP, the concern that many in the industry have is that it would be more so for the therapy after the fact. You know, the chiropractor, the MRI facility, the physical therapy, that type of thing, which actually is the treatment that gets you back to 100% after an accident.
I got you. So it's less so much the immediate addressing of it as it is just the long-term care, the fallout consequences, and the recovery process.
Yeah, correct.
Now, how would that pertain to restoration of materials as well, like with regards to property?
The property damage would be increased under the last 5 proposals or so to the $25,000. Currently, it's only $10,000 in property damage for an auto. The biggest problem with the current bill is that it's set from late 1970s numbers. Those $10,000 for an individual and $20,000 for an accident was from, like, I think 78, and then it actually came into play in 79. And that money hasn't been increased at all, so it's never been adjusted for inflation. If you're looking at $10,000 from 1978, 79, you're looking at about $42,000 today.
Exactly. So the money doesn't go nearly as far as it used to, and everything's a whole lot more expensive.
Yeah, I think we see generally, hospital bills are run around $8,000 just, if you have neck and back complaints. And so a lot of that PIP is exhausted pretty quickly, and then there's not, an awful lot left for the therapeutic treatment that a lot of people need to really get, back to health.
Well, depending on which hospital you go to, I've seen some where somebody gets, 2 or 3 CT scans, and they've got an $18,000 to $25,000 bill as well, which takes up the entire $10,000 of PIP benefits. So that way, when you need to start treating for therapy, you're already done with your initial benefits, which is then requiring the doctors to see you basically on credit the entire time that you're treating with them.
That could get real expensive real fast.
Correct. Well, and I'm not sure if most people even understand like what PIP is, or, a lot of people will hear, Florida no fault or no fault benefits, and that is your PIP. In fact, Tom and I have heard so many clients say, well, we can't go after the other person because Florida's a no fault state. And that's not what it means. What no fault means is that regardless of who causes a collision, your own insurance company is still going to provide you that $10,000 in PIP benefits. So whether you are the person that created the accident or whether you were the recipient of the accident, so to speak, the insurance company that you have as your personal is still going to pay that $10,000. So that $10,000 is the quote no fault benefit.
So that's the part that's absolutely getting paid out regardless. And then you can start worrying about whether the other guy's got proper coverage for it, or if your uninsured motorist coverage is going to step in and become a factor.
Yeah, absolutely.
And that law creates additional hurdles to actually go against the defendant. You have to have a threshold injury, a permanency, and before you can actually really go in court and file for your pain and suffering. A lot of clients, are very confused about that in the beginning of stages of the case.
So it's not even something that's necessarily addressed in acute care. If that's something that can just be treated and paid for and resolved, that's something that's got to be an ongoing or a life-changing circumstance about it.
Yeah, permanency, basically from a doctor saying that this injury is not going to go away. It's going to require additional treatment, gets you into court basically, and get you that additional pain and suffering component to it. If they repeal all of that and move to the 2550, so it would be easier to move into court and to recover for people.
But not necessarily easier to lay out the long-term treatment programs and everything that you're looking at up front.
Yeah, there'll be definitely some logistical hurdles and changes to the way things are done right now. There are definitely a lot of providers out there that just focus on accident treatment and things, and a lot of this PIP is the reason why that money is available, and they want to recover that. Health insurance and just self-pay is more difficult to collect. The PIP is a little bit more automatic, so that's where we have an industry, and there would be definitely some functional changes to how things are done and how treatment is handled.
Now, how would that affect the legal process as it pertains to taking an issue to court and trying to seek some satisfaction and relief through the courts to do some financial recovery in that respect?
It should allow a little bit more access to the courts. Right, like I said, right now you have to have that permanency in order to get there, and to really make it a viable case that's worth the time and money to go into court. So probably a little bit more access. It would create a little bit of additional money to go after for clients. You have the $25,000 currently. You would have $10,000 of PIP to go through, and then there'd be a $10,000 recovery at the minimums. And the other problem that we have currently is that minimum is a waivable minimum. So there's a lot of folks that are driving around with zero, and that hasn't been addressed either. That's always wrapped up in the rest of the bill and the rest of the issues. So.
And I understand this proposal has gone forward about removing PIP before, but has so far not been able to complete the whole process. The last time it got to the governor's desk and the governor vetoed it.
Correct.
Yeah. It's been a number of times. I think it's been twice to the governor's desk over the last 8 or 9 years, this most recent one this session. But yeah, there's always a lot of difficulties. There's a lot of interest groups. Hospitals are really concerned about being able to recover the emergency treatment that they provide, and obviously they have a powerful group up there in Tallahassee to discuss that concern.
Well, and even I think it's important to realize, too, that over the years, the insurance industry has been lobbying to try to get less and less benefits to the consumer. Because when PIP first came out, like Tom had mentioned, there was that full $10,000. It also included massage therapy and acupuncture. However, so many people would get the massage therapy, which was helping. However, the insurance companies were paying out so much money that around the 2012 timeframe, they successfully lobbied the state to actually remove massage therapy as part of the PIP benefits. So now when somebody has a car accident and they're getting treatment from their physical therapist office, their chiropractor office or whatnot, they are not allowed to get massage therapy. And if they do get massage therapy, they're actually paying out of pocket for that because the PIP benefits will not pay for it. And that's something that now, from what it appears, now the insurance industry is realizing, well, we're still having to pay out so much money because of the PIP. So now I think their next step is, well, let's just get rid of the PIP and have the mandatory BI. And personally, I think that they recognize that so many providers are not going to be able to survive because they don't have that normal stream of income coming in along the way as the clients are treating. So I think that part of this is a a ploy to be able to get the PIP stopped, knowing that it's going to actually reduce the overall settlement recovery at the end of the day, because people are not going to be able to get the treatment that they would otherwise get because of having those PIP benefits available.
Which creates the opportunity for some legal counsel and intervention on behalf with the courts and the law to try and make sure that our consumers are able to get the care that they need and get the issues that they've got addressed properly.
Absolutely.
Yeah, it's always an access of care issue that we're always concerned about. There's a limited amount of providers that are willing to deal with accident injury clients, patients. And, you know, as the laws get more difficult, the more those providers are a little skittish of dealing with it and getting involved in that process. So, you know, that's always a concern that we're looking at when they're changing these laws and what it is. We're trying to look to the future, how it's going to affect our clients' lives and their ability to recover when they're, you know, not at fault for an accident.
Well, Jacksonville, if you've got some opinions on this, we'd love to hear from you. 855-765-1045 is the number to call, and our lines are open. We've also got the availability to answer any other legal concerns you might have. Scott Burleigh and Tom Normandeau from the law firm of Farah and Farah standing by to take your calls today here on Legal Live. Again, 855-765-1045. We're going to take a quick break. We'll be back for more, and we'll start taking your calls when we return here on 104.5 WOKV, Jacksonville's News and Talk. Jacksonville, we are back on Legal Live. 855-765-1045, the number to call. 855-765-1045 puts you in touch with our legal experts. We got Scott Burleigh and Tom Normandeau from the law firm of Farah and Farah sitting in with us today. And we're joined by Shafalka Bhatnagar as she is stepping away from the traffic desk to join us here on Legal Live. And we've got Stephen in Palatka with our first call of the day. Stephen, you're on Legal Live.
How you doing, Steve? Steve Rock and Roll here. How are you?
We're doing good, bud. How are you today?
Good. Fine and dandy. I do have a question about workman comp. I'm at the point where I think I have to contact the other side that owes me money retroactive from 5/19 when they stopped the entitlement. I was a jailer over at the Hastings Youth Academy, got pushed by a kid on a wet floor, banged the head on the concrete, had an out-of-body experience, came back, and still vertical. But I'm walking and talking and trying to chew gum at the same time. So I had my primary caregiver authorized the neurologist and orthopedic referrals, and went to both. The neurologist originally said there was one test that they didn't have the machine for. The primary caregiver did the original X-rays and stuff, and when I went to respond to per workman comp to the initial examination at Fair Spot, they wanted to send me stats to the hospital. I said, well, I'm not going to go because of COVID, and I'm going to stay with my primary caregiver. And so we had the referrals going. They stopped the orthopedics. They said I was full capacity, and neurologists eventually said, well, you're all set. But we had a lawyer, as you know, contact them, and the neurologist has said that he had 2 more tests that we're going to get going. Now, don't forget, one of the machines they said was down, so that delayed some time. So the companies, Coventry and Century, are the ones that are controlling the money retroactively that they have stopped my workman comp entitlement, 60% of what I was making since May 19th. So I feel that's retroactively owed to me. And they want me. I did call the neurologist, finding out that the primary caregiver saying the abrasion on the top of my scalp, anything to do with the head is up to them. Now, administrative law, the neurologist says that you're done. The orthopedic says you're done. You're done. However, I was able to get 2 tests approved by the neurologist. Now, he had tried contacting Century and Coventry to get the approvals, go ahead with the three tests. Delayed. They haven't contacted them. Been unable to communicate. So time goes on. I did call up, and I said, "What's going on?" I said, "We've been trying to get in touch with them, and we got one test pending and one test approved."
Oh, wow.
And so we had one. Okay, go ahead.
I was going to say, Steve, are you currently represented by an attorney, or what stage is
Yes,
at? Okay.
yes,
And they're just having some difficulties contacting the.
yes.
Yeah, unfortunately,
and the communication problem between attorneys and I think, and I want to get some paperwork generated to the outside saying this is what we feel is owed to grievously take it away, reconversate, because you want to go again now to these two approved tests. And I got my mileage reimbursed, but here they want me to go back. I'm not done. How can they take the money away if I'm not fully, I still have tests pending to see the degree of problem enormous, check the top of the top of the skin abrasion on top.
Yeah, it's a good point. I mean, the workers' comp system is a tough system that people are in.
Like
you said, it's an admin law system, so there's a lot of checks and balances. It's a very slow, deliberate process, and it's often controlled by those workers' comp insurance companies, which adds frustration to any client. That's
what gets me is the mediation was done, and we thought we had a mediation going at the last second. I find out it was canceled the day of.
Yeah.
So, everything I had scheduled.
A lot of that delay is there, I think, almost intentionally to make it a difficult process for you.
I hear you.
We would always say, if you were our client, we'd say come in and sit down and talk about it and kind of, game plan it to see what the next steps are so you understand that process. And
absolutely. Sounds like a plan, Stan.
That's good.
Well, and really, I think that the workers' comp system that Florida has, for me personally, looking at it, I think it's really a conflict of interest in its basic form, because the workers' comp insurance is the one that decides what doctor you can go to and decides how much treatment or how long you can seek treatment from that provider. And they're the ones that generally are giving the provider the direction that, okay, you can treat somebody for this amount of time, and we're going to approve or not approve this or that.
Yes.
So it takes away a lot of the freedom that the doctor has to be able to provide the treatment that they want to treat the patient with because of the dictations. But really, I mean, you see that with health insurance as well. How many times do you see health insurance that requires pre-approval for this and doesn't provide this treatment for that because they don't think that it's necessary, or they want you to try these 3 or 4 different other things before they'll approve this other procedure. So unfortunately, you just kind of have to walk through and play the game with the rules that are established, just like we're talking about with auto insurance. It still has its own little rules and hoops that you have to jump through in order to play by their rules, and it's their game, really.
Yeah.
And you'd be surprised of how many times that workers' comp discharges the client patient, but when there's a third party defendant, they have to go back to treatment and continue to treat for another year or so before they can make that defendant liability claim afterwards. It's shocking that how many people have to deal with that situation.
Yeah, it's a comprehensive mental health youth academy. So the kid who pushed me is part of DJJ, and I haven't tried any civil thing with that because I want to get myself 100%, and I'm lucky to be, like I said. But I think with the mitigation things here with COVID, and it seems to be, like you said, it's hard. You have to get all the T's crossed, and all the documents have to be right on the money, everything like that. But with the time factor involved. I did make an appointment for the one test that was approved. It's going to be later on this month. They wanted to do it on the 4th, so I was pretty much saying, hey, we got to get something going here. I don't see why correspondence, it has to be somebody the law firm has to reach out to Coventry or Century and say, you have to pay this guy this money if you want him to go to drive to the 2 appointments that are necessary to determine how it is with neurology if he's 100% or not. How can you say it's almost like they can switch? I know we're fighting the casino here, and there's only so many chips.
Yeah.
Right.
But do you think I have a chance if we reach out to Coventry and Century that they might compensate me retroactively from May 19th?
You got to look at each case individually, but I think it's absolutely something you should discuss with the attorney and see what else is there. You always want to maximize, the recovery. Everything that's available to you, you want to make sure that that's what you're getting at the end of the day. I will say the one bright side is you should be
Yeah.
happy you're still treating. If you had a 2019 accident, workers' comp is usually discharging people well before that. So, the fact that you still have that coverage, you're still getting that treatment is a positive sign. I
Well,
would say.
did I say 2019? No, it was October 29th, 2020.
Oh, okay. Well, still even a year.
It is a year. It's just over a year, sir. Please be advised. Oh my goodness, I said 2019. Anyway,
Stephen.
Math is hard, brother. I understand.
I'm going to contact the law firm and appreciate. And you keep on rocking, Miss S. You're doing a great job. Keep on rocking. Break a leg.
Thank you, Stephen, for calling in. We do hope you get the communication reestablished
Checked out.
for your workman's comp.
Yeah, it's going to be a done deal on Monday. All right, you guys take care. Stay safe.
All right.
Have a great
Have a
weekend.
safe Saturday,
Great
Stephen.
Merry Christmas and happy Thanksgiving coming up now to you all.
Thanks, Stephen. Appreciate the call. We've got Jim in Jacksonville with a question regarding settlements. Jim, you're on Legal Live.
Yes, I would like to know if in a accident where an individual hits someone in the parking lot and the jury agrees that the party is guilty, and they come back with a low settlement, and this individual has a permanent back injury, does the judge have the right to increase the amount of money that the person is going to need to be treated for the rest of their life?
No, generally, no would be the answer. I don't know why they, the jury verdict is the jury verdict. Sometimes if it's so egregious that the judge can remove it, but that's an extremely rare situation. That's why you go to that independent trier of fact and let them figure out the information. Most of the time, how that gets changed is through an appeal. If there was some kind of a mistake in the process, there was an issue, something procedural, or something information that was allowed in that shouldn't have been, that's a way to change that number. But usually, you don't want the judge just unilaterally making different changes, going over the jury. We have that jury process on purpose. We want them to make that decision. But the question is, was all the information there for them to make the right decision?
Well, yes, it was there. The situation was that one of the jurors was against anyone that has anything to drink. This individual had a beer for dinner. The accident happened 4 hours later. The person felt they were at fault because they had a beer that night.
Right.
So therefore, that person wanted to award the individual a low amount. But the person still has a permanent back injury that has to be treated every 3 months. And based on the amount of money that was awarded because of this individual, the person's not ever, they're going to be paying it out of their pocket for years because the person, thought they were guilty or they were at fault for the situation, and they truly weren't. The person ran into them.
Right. So one thing to point out, Jim, is that you've got 6 jurors. It's not one juror that makes that decision. So the other 5 would have had to agree with that. So if you've got, and really that's what you get kind of casting lots whenever you have a jury chosen, is it's simply a jury of your peers that are chosen at random. So you never know if you're going to get someone that's opposed to the situation or in favor of the situation. And if you have the situation where one particular juror is standing out, yes, they have the ability to influence the other jurors, but the other jurors also have the opportunity to influence that one person as well. So if the jury verdict came back and it was a low verdict, all the jurors were on the same page. Now, they may have seen something that you did not see, or they may have perceived something in a different way to lend to that particular verdict. But that's your day in court, brother, and that's unfortunately how it goes. Unless, like Tom mentioned, unless you have some reason that you're able to appeal it, thinking, okay, the jury should not have heard this information. It was objected to, but the judge continued to allow it. That would be a situation where you could potentially appeal it, because maybe if the jury did not hear that particular piece of information, maybe they would have not come to that same outcome.
Yeah, and this is why so many of the cases settle before you get to a jury. There's definitely risk involved in a jury trial and what decisions they're going to make, and they are final decisions usually. So a lot of times it's in a client's best interest to get it resolved before, when you know what the number and the outcome is going to be, and you can make those kind of calls, safely and feel comfortable with the result. When you go in there that day in court, that is the day, and that's also the end of it.
But if the other insurance company won't agree to an outside settlement, when the person's clearly at fault that hit them, then you have to go to a jury trial.
Sometimes that's, part of it is just strategy of, whether you're going to actually go all the way to jury trial. But again, that's the legal system that we have, where you can try to get a settlement. If not, you file suit, and then you have to go through the whole litigation process. Most cases are resolved within that litigation process, primarily because either the plaintiff, which was the person that's hurt, plaintiff sees that, okay, we are not as strong a position as we thought we were, or the defense, which is the insurance company, recognizes that they are not in as strong of a position, and one side or the other agrees that they need to either raise their number or lower their number. Because like Tom was saying, when you do go to jury trial, you are putting everything in the hands of those 6 people. And if they misperceive something, or they look at it in a different way that's not in a positive light to your side, they may go against you, even though to everybody else it seems pretty clear cut.
Right, and I can understand that, but that's the reason I was really asking the question. If I thought maybe from a legal standpoint, because the judge rules the trial, if an individual is underpaid and it's proven this is a lifetime injury, the judge would say this is not acceptable. You're going to have to go back and discuss this further.
No.
Just common sense would tell you. So just like if someone's paralyzed and they come back and they say, okay, we're going to give this person $200,000, which is ridiculous, for the rest of their life, and this is a 30, 40-year-old person.
But Jim, one thing to keep in mind, though, is that every case has different facts. So there may be something called comparative negligence, which means the driver who got injured, they may have contributed to how the accident happened. That can be taken into account. If the person who got injured maybe had already had some of those injuries in the past, that can be taken into account. So really, the jury may filter out some of that prior treatment. The jury may filter out some of those medical expenses or that long-term permanent impairment, because they're looking at other things. Because it's not just the plaintiff or your attorney bringing your side. You also have the insurance company that has a defense attorney who is also bringing up those other points, saying, hey, well, you realize Jim also had this other stuff that was going on before the accident, or Jim had also been treating with this doctor for the same stuff. So the jury's not just hearing your side of it. They're also hearing somebody trying to discredit what you're bringing as well.
And you should understand the role of the judge as well isn't necessarily to serve as an advocate one way or the other, but to serve as the arbiter between the two, to make sure that rules are complied to, that all of the legal precedence is followed. But it's not the judge's job to adjust a settlement or anything. It's your attorney's job to be your advocate and to present the best possible claim with the highest possible return, and in doing so to justify it with all of the representation that says this is what the claim is worth.
Okay. All right. I understand. Okay. Thank you very much.
Thank you, Jim, for calling in.
Jim, we appreciate the call today. Have a good weekend, brother.
All right. Thank you. Bye.
All right. Well, when we get back from this upcoming break, we're going to discuss the 5 parts of what PIP means and how the difference between no fault and at fault between Florida and Georgia.
And if you've got a couple of questions left, we've still got one more segment for you to reach out to us at 855-765-1045 as Legal Live continues on 104.5 WOKV, Jacksonville's News and Talk. Jacksonville, we are back on Legal Live, 855-765-1045. We've got a couple of minutes left.
All right. Well, let's dive right back into the differences between at-fault and no-fault states, like the difference between Georgia and Florida. And I really am interested in knowing the 5 parts of PIP, if we can hit on those real quick. Go for it, Scott.
Oh, sure. Real quick. So PIP just covers 5 things. And really, no-fault versus no-fault or at-fault. Like Georgia's an at-fault, which means you don't necessarily have that initial medical benefits right away. So you have to get doctors to either bill your health or just see you and basically keep your bill on credit. But what PIP covers in Florida is they're going to pay 80% of your medical expenses, and they're going to pay that directly to the providers. They will reimburse you 80% for any prescription medication. They reimburse you 60% for any lost wages that you have as a result of the accident. They reimburse you mileage to and from the doctor's appointment.
Oh, that's great.
And I think the rate right now is about 52 cents a mile, so that definitely is going to cover your gas money.
Well, it covers at least, yeah. Considering gas is $3.50 right now.
And then the last but not least is they cover household services. So, for example, if you can't clean your house because of your pain, or you can't do your yard work, if you hire someone to come in and do those, you provide the receipt, and then they'll reimburse you for those. But it's a first come, first serve. And once that $10,000 is paid out, it stops.
Oh, I see.
So that's an important thing to keep in mind as well.
Okay.
And remember, a lot of them you're being reimbursed. So there is some out of pocket, and then you eventually recover on some of those things.
Yeah, absolutely.
Right. So it's Tom was mentioning during the break that in Florida there are 15 million drivers and we have 26% uninsured. So that's like 4 million uninsured drivers, just completely nothing. So that makes me wonder about the at fault versus not at fault. But maybe we can.
Maybe we'll pick that up on another show.
We might have to pick that up on another show.
We've reached the end of the hour. Sadly, they only give us an hour to take advantage of the opportunity to work with you guys, but we appreciate it. Thank you so much to our special guests today, Scott Burleigh and Tom Normandeau, coming in from the law firm of Farah and Farah. They are our proud sponsors here on Legal Live on 104.5 WOKV's Legal Talk Show. Look forward to talking to you again next Saturday. Legal Live every Saturday at noon on 104.5 WOKV, Jacksonville's news and talk station.
Looking for a way to make quick cash? Making cash with DoorDash is super easy, guys. I love driving around my town, and now I can do that and get paid. Not to mention the sign-up process was so easy. Download the DoorDash driver app today to get started.